Well, greetings to everyone. It's been a little while since I did one of my Law Before Lunch mini webinars, this is now July 2023 when I'm speaking. And at the beginning of the year, I was just really, really busy. Then I had COVID, not hospitalized, but I had it really quite badly, which took me about a month or two out of my schedule. And then I had a little incident with the living room door, which we don't need to go into at any length. The black eye is now gone, as you can see, so I'm actually okay, and that's fine. So what with one thing and another, I haven't really had time to do something. Anyway, I'm conscious that we've now got into sort of school holidays, and so I thought it's a bit silly trying to do a webinar when everyone's likely to be going away. So I thought I'd do something that goes straight to YouTube. Let me know if you think that's a good idea. As for me, my name is Richard Stevens. I'm a commercial lawyer. I work in the IT sector and have done so for many years. If you want me to help you get the right contract together, I can certainly help you in that department. I provide training courses as well on commercial law. If you like what you see here, then ask me if I can help you provide training within your law firm or in-house legal department. I also work as an arbitrator and mediator, especially in the areas of technology. Law Before Lunch was an idea I had for providing mini webinars, no more than, say, 20 minutes or so. It proved to be incredibly popular. As I say, I haven't had time to get a mail out for that recently. So I thought I'd do this looking at a recent case on indemnities. Now, of course, when it comes to any mention of indemnities, always a chance to plug the book, modestly entitled Stevens on Contractual Indemnities, available off Amazon, 4.6 stars. And if you want to know everything about how modern indemnities are construed and applied, that's your best jumping in point. I want to look at a recent case looking at indemnities, and I want to try and tease out the practical implications of what those indemnities actually mean, because there are a few of them, and they need to be carefully understood, and they do come up from time to time. So let's leap straight in and take a look at indemnities. And the two issues I'm going to be talking about are, firstly, the Canada Steamship case, and secondly, what I call the litany. Canada Steamship is a case, and you're probably wondering why on earth I'm telling you about a Privy Council decision back in the 1950s. If you don't know the case, you almost certainly, as a lawyer, have seen its effects. When you see a cap on liability or whatever it may be, it will say something like, our liability for any breach of contract, breach of statutory duty, or tort, brackets, including negligence, close brackets. Why does it have that formula, tort, brackets, including negligence, close brackets? What's it all about? Well, it all comes back to Canada Steamship. It laid down three guidelines. They quickly became sort of fossilized as sort of rules of presumptions of meaning, but they're really properly understood. They are guidelines, approaches for construing liability and indemnity clauses. They're pretty much a dead letter as far as liability clauses are concerned, and there are other concerns there. I'm not talking about those. However, as regards indemnity clauses, they're sort of pretty much on life support. The first guideline says that if you've got an indemnity, effect will not be given to it so as to protect an indemnified party against the consequences of its own negligence, unless it contains express language to that effect. In other words, if I indemnify you, I'm not to be taken as indemnifying you against your own fault. I'm not acting as an insurer for you. But what happens if negligence is not expressly mentioned? Keep that thought in mind. The second point that came up in this case is what I call the litany, and what the litany actually means. Do you know when lawyers draft indemnities, very often they don't draft anything at all. They just take wording from a template clause, and they typically throw in this litany of expressions. But the litany is important because it marks out the scope of your indemnity. Any and all actions, costs, claims, losses, liabilities, proceedings, or expenses, including reasonable legal expenses. why do lawyers put in all these terms, some of which actually overlap? What exactly is a liability? If I indemnify you against claims made by a third party, if a third party makes a claim against you and you settle that claim with a third party, can you simply pass the settlement value through to me to pay under the indemnity? Do you have to establish a liability, an underlying liability, before the court is going to enforce the indemnity? And what about a claim? Does it have to be a well-founded claim? What if it's a claim brought by a vexatious litigant without a shred of evidence to support it? All very interesting questions. The case I'm going to talk about today is Paggy and Cigna Insurance Services. Cigna was a management buyout. Under a business transfer agreement back in 2003, they bought certain insurance operations from Royal and Sun Alliance. One of the operations that they bought had been operated by Paggy, and they had been selling PPI insurance, payment protection insurance, through its agent Next PLC. Now, as we all know, since then, not at the time, but since then, of course, there's been this whole flood of PPI mis-selling claims, complaints, allegations, all the rest of it is over now, but that's what happened. But that happened after the business transfer agreement. At the time, of course, everybody knew you could make a complaint against your insurer, but the full extent of this flood of PPI mis-selling complaints wasn't quite appreciated. Cigna offered an indemnity to Paggy, and we'll have a look at how Canada Steamship interacts with the scope of that indemnity. So first off, Canada Steamship and the problem of fault, of negligence. Here's the indemnity in the case. Cigna, now remember, Cigna is the buyer. They're buying this business, and they're indemnifying Paggy, who is the seller of the business for our purposes. Cigna shall assume liability for and indemnify and keep indemnified Paggy against the payment or performance of the liabilities with effect from the completion date, and any and all actions, costs, claims, losses, liabilities, proceedings or expenses, including reasonable legal expenses, which Paggy may suffer or incur in respect thereof. Now, liabilities has got a capital L, so the I eagerly goes to the definition, and that simply means all liabilities of the business. But business has got a capital B, so the I eagerly goes to the definition of business, and the judge found in that little d there at the very bottom of the slide, that expressly referred to the activities of Next PLC as agent for Paggy in selling this PPI insurance. Okay, so we've got the buyers, and they are apparently, according to this, indemnifying Paggy against things that Paggy's own agent had been doing wrong. Could that be right? How does Canada Steamship come into it? Now, there's been quite a deal of case law on this, and it comes down simply to construing the words on a page. And the judge looked at the language, and she decided that the language was certainly broad enough to capture PPI mis-selling by Paggy's agent. It referred to all liabilities of the business, and the business expressly included Next PLC's activities. The whole idea, she noted, of this business transfer agreement was that Cigna will be taking on these insurance operations as a going concern. Paggy would then step to one side, and so Cigna would, in effect, be taking over all the business, the good, the bad, and the ugly, and Paggy would be held harmless. They would jump clear of any wreckage. So in other words, it was up to Cigna to satisfy itself about the scope of the risk that it was undertaking. And as the judge commented, the task of the court is to interpret the words used, fairly applying the ordinary methods of contractual interpretation. And the fact that the liabilities with hindsight have proved to be very significant may only indicate that with hindsight, it was a bad bargain. In other words, a bad bargain possibly for Cigna to have entered into. Interestingly, she said, well, it wouldn't cover any fraud, or she didn't make any findings about fraud or dishonesty by Paggy's agent, but she said it wouldn't extend to fraud or dishonesty by them, because for that you would need absolutely express wording, because it would be, as one judge put it in another case, an extraordinary bargain to be indemnifying one party against the fraud of that other party's agent. It would be an extraordinary bargain, and you would have to have absolutely clear language to make clear that that was part of the bargain. So we move on now to the litany. And here's a good example of a litany. If you've got your pen and paper handy, you can write it down if you like. All actions, proceedings, losses, claims, damages, costs, charges, expenses, and liabilities suffered or incurred, and all fines, compensation, or remedial action or payments imposed on or required to be made by the company. It's a very good, very thorough litany. But before you try using it yourself, you might like to remember that this was the indemnity that went all the way up to the Supreme Court for decision. People say that indemnities make life very clear, very simple. Having wording that goes all the way to the Supreme Court to find out what it actually means doesn't strike me as being very, very clear. What were the words in the Paggy and Cigna case? Well, we saw it was an indemnity against the payment or performance of the liabilities and any and all actions, costs, claims, losses, liabilities, proceedings, or expenses, including reasonable legal expenses. And two sub-issues came up from this wording. What about if I indemnify you against third-party claims? If a third party makes a claim against you, almost certainly you're going to contemplate with your lawyers coming to a settlement with that third party. To what extent can you claim under an indemnity with that sort of wording if you've actually settled? Does liability mean an actual liability? Does there have nonetheless to be an investigation to see whether there was an actual underlying liability before the indemnified can make a claim under the indemnity? Interesting. Paggy said the indemnity covered both an actual liability and any reasonable acceptance of a liability, including reasonable bona fide settlements of claims or complaints. And Cigna said, well, liabilities is not a defined term. It should refer to a legal liability. It doesn't say anything here about regulatory investigations or compliance reviews, or as Paggy did in this case, they went out and, in line with the spirit of the FCA handbook, this being a regulated business within the financial services community, they actually went out and found potential complainants and settled with them, notwithstanding that those complainants didn't even know that they had a complaint and might not have made a complaint even if they'd known about it. So did the indemnity cover payments made for breach of the FCA handbook, regardless of whether there was or not a complaint made? What about liabilities? Well, when you looked at this litany, as the judge did, and she commented that it was extremely broad, as we have seen, very broad in scope: actions, costs, claims, losses, liabilities, proceedings, expenses. She pointed out that actions, claims, proceedings rather indicated that not just actual established liabilities were intended to be included within the wording. A claim, she thought, could mean something as broad as just a claim made prior to any formal proceedings being commenced. If you use words like claims and proceedings, it's not necessarily limited to just legal proceedings. And there is good authority to show that when you have an indemnity, that can cover the reasonable settlement of claims made by third parties. The classic case on that, and one cited by Paggy in this case, was the Cumming, Ching and Oriental Tube case. This goes back to 1979. And as the Court of Appeal there said, if it was reasonable to settle, and it's nearly always going to be reasonable to settle, if it's reasonable to settle and if the settlement was reasonable, then the court will say that you don't have to go establish an underlying liability. You can simply pass that settlement through under the indemnity. Another case on this is the classic case of Rust Consulting against PB Limited. Again, people say indemnities make life so much easier. This was a case that went to the High Court on an indemnity twice, and twice had an outing in the Court of Appeal. But when I say that settlement has to be reasonable, what the courts tend to do is take a hands-off approach to that. It's reasonable in the sense of not unreasonable. General Feeds and Slobodba Plovidba Yugoslavia is probably the high watermark. The court decided not to overturn the decision of the arbitrators, who had found that a settlement with a third party was reasonable, notwithstanding that at the time of the trial, there didn't seem to be a shred of evidence to support the claim made by the third party, or at least very little evidence to support it. But the arbitrators advised themselves correctly as to the law, and the court was not prepared to disturb the arbitrator's finding. What about these complaints? All this stuff in the litany. And the judge noted that the indemnity didn't, as such, refer to complaints made to a regulatory body or to a body set up by a regulatory framework, such as some sort of ombudsman process. But again, she noted that this was an extremely broad indemnity. Actions, costs, claims, losses, liabilities, proceedings, or expenses. And we've seen that she was prepared to accept that claims, proceedings, these things could be claims outside court proceedings. It could result in a complaint falling within the indemnity proceedings. Similarly, again, if you're dealing in a highly regulated environment where people are complying not only with the letter of the law, but the spirit of the FCA handbook, then simply going out and finding potential complainants that you can compensate them, even though they might not have known that they had a complaint, or might not even have made a complaint, again, is something that could fall within the scope of the indemnity, because it's within the reasonable contemplation of the parties when they're actually drafting an indemnity into a contract existing within something like the financial services community. So what do we make of all of this? There's no law on indemnities. There are some very interesting cases in the 19th century which still get an outing in modern indemnity cases, trying to find that there is some law associated with this. Canada Steamship should be seen probably in the same light. It's indicative of an approach that the courts used to have to cutting down the scope of an indemnity in favor of the indemnifier and against the interests of the indemnified. It's not a mindset that modern cases show that the courts have these days. And as we've seen, the court in this case simply looked at the words on a page and they said, using ordinary principles of contractual construction, this is how we will construe it, and it construed it to mean that it included fault, not dishonesty. There was no finding of dishonesty in this case, but it wouldn't go so far as to cover dishonesty, but it would, on its face, cover fault. So Cigna was taken to be indemnifying Paggy for any faulty actions taken by its agent in mis-selling PPI. Think about that litany. It's become very common for judges just to simply swipe a litany out of some other template clause. If you're the indemnified party, there are plenty of good reasons why you want the litany to be as broad as you possibly can, to sweep everything up there that you could possibly want to complain about and include within the scope of your indemnity. Very good idea to do that. If you're the indemnifier, rather different considerations apply. Do you mean by liabilities any settlement which the court is unlikely to scrutinize very closely? Is that what you intend to mean? What about claims? Do you intend there to be just claims by vexatious litigants with not a shred of evidence to support them? Do you intend claims proceedings to mean claims outside the courts, complaints brought by in front of, say, an ombudsman or some other regulatory tribunal, or complaints made to a regulatory body? Especially if you're dealing in a regulated sector, the financial services sector is but one of the sectors you might be considering. Have a think, if you're the indemnifier, about the scope of the litany that you're offering. The courts will have a look at it. They'll look at the individual elements of it, and they'll also take into account that the more elements there are there, the broader the construction they're prepared to give to the indemnity as such. Well, that's what I wanted to say today. It was nice to be back in front of the old jellyfish, the old trademark jellyfish. I haven't done anything like this for 6 months, so I hope you enjoyed. If you're interested in hearing about how I can help you provide training, if you're a law firm or if you're an in-house legal department, do please get in touch. You can buy me a coffee as well. It's not obligatory. You might be interested to know that I'm setting up a new service whereby, in addition to my annual update on contract law, which in fact I offer throughout the year to various law firms, I'm actually starting an online quarterly update as well. If you're interested in that, reach out to me and we can talk about how I can provide that to you. But other than that, let me know what you think. Do you prefer this to go straight to YouTube, or do you prefer to have the excitement of a fixed time webinar? Let me know what you think. Do feel free to get in touch. Other than that, wish you all the well. Thank you for your attention so far. Hope to see you again very shortly.